Good afternoon, everyone. My name is Tom Reynolds with Export Solutions, and I'd like to welcome you to today's webinar, which is called Due Diligence for Mergers and Acquisitions, centered around export compliance. I see that a few people are still joining, and so I'm going to take a few minutes to go over some housekeeping items, and then I will introduce today's speaker, and we'll get started with this session. First of all, just a quick disclaimer, which our lawyers put together for us. Basically, in a nutshell, what this says is that we are experts on the regulations. However, if any of the information that we present in this session conflicts with what is written actually in the statutes and the regulations, the ITAR and the EAR specifically, then obviously those regulations are the governing set of rules that you should follow. Just some overview of how this webinar works. Hopefully all of you can hear my voice and see these slides right now. Each of you should have received a confirmation email when you registered for this. If for some reason you can't see the slides that we're presenting or GoToWebinar is not working, I would advise you to go back to that email and click the link, which should then authorize and create the GoToWebinar toolbar to start working within your computer environment. Sometimes there are firewall issues that we run into. So if you do have any technical problems, please contact us through the chat or the questions toolbar, and we will try to resolve this for you if we can. Everyone's going to be on mute throughout this call. What we found in almost 3 years of doing these is that it's just better to keep everybody muted. And the way that we will handle questions is if you do have a question, in fact, we have some questions coming in already, just go ahead and type those into the questions bar on your GoToWebinar toolbar, and then we will see those. And at the end of this session, after the presentation is done, we will hopefully have time to address those questions. We would like to get to as many of them as we can. Sometimes we cannot get to all of those questions, and so in those instances, we'll be happy to follow up with you offline to address any further questions that you might have. One of the questions that we most often get, so I like to address this up front, is will you be sending us a copy of the slides? The answer to that is that we will not proactively email these slides out to you. However, within about a week from today, so by next Wednesday, if you go to our website, which is exportsolutionsinc.com, and you click the webinars tab where you registered for this session, you'll look underneath the section called archived webinars, and we will have a copy of the slides for you to download. We'll also are recording this session in Windows Media format, and there will be a recording of it which you can download and view and listen to for free. So if there's anybody in your company that happened to miss this, or if you wanted to go back over and hear a certain portion of it again, that will also be an option for you. And I just want to remind everyone that the slides and the presentation that we provide to you are for internal company use only. We do host a variety of free webinars throughout the year. Our next one that's going to be coming up is on June 10th. It's also at 1 o'clock Eastern Time. We host them on the second Wednesday of every of the month at 1 o'clock. And this next one will be looking at export control reform. Many of you probably are familiar with this or have heard about export control reform. It's a process that's been underway for a couple of years now in earnest. And so we've already have provided some updates on this in the past, but we're going to be looking at some of the newest USML categories and what the changes are for them, and how that's moving, how some of these items are moving over to the EAR, as well as just providing a general update on where things are right now with export control reform. So if that's of interest to you or you would like to join us for that session, I'd recommend that you go online and register now. Our webinars are capped at 100 people, so it's a first come, first served basis for those who register. So today I'd like to just spend a moment and introduce our presenter. Jim McShane is a senior consultant for trade compliance here at Export Solutions, and I'll just give you a little bit of his background and then turn it over to Jim. Jim has more than 30 years of international trade compliance experience gained through a variety of roles both at the U.S. government and the exporting community. For more than 20 years, he served with the U.S. Department of Homeland Security, Immigration and Customs Enforcement, conducting specialized investigative assignments around export control. And for 5 years, Jim acted as a senior advisor to the director of the U.S. Department of State, Directorate of Defense Trade Controls, the DDTC, which, as many of you know, is the government agency that is responsible for ITAR compliance and enforcement. Twice during his career, Jim has been nominated and approved as a Special Compliance Officer pursuant to 2 separate consent agreements between the Department of State and multinational corporations. And for 8 years, Jim served as the Global Director of Export Compliance for a multinational group of companies which was headquartered in Paris, France. Jim is adept at conducting compliance audits, developing and implementing training, and designing compliance systems with a focus on due diligence, among other things. And as you'll soon find out, he's also an expert and has lots of experience working with companies around export compliance, either as part of a merger, an acquisition, or sale. So Jim joins us today from Vero Beach, Florida, where I think it's probably safe to say he has the best weather of 90% of those of us on the call. How are you doing today, Jim?
Very good, thank you, Tom.
Great. Well, thanks for joining us, and go ahead and start with the presentation then, Jim, and we'll take questions as we go.
Thank you again, Tom. Good afternoon, everyone. Good morning, if there's anyone from the West Coast. I wanted to take this opportunity of the webinar to cover a topic that has been covered in plenty of training sessions and in advice given by both departments of Commerce and State, but I wanted to come at it from a slightly different aspect. The presentation isn't going to do so much with the notifications and the regulatory requirements. It's going to do predominantly with those 2 words that are so absolutely necessary in these situations: due diligence. What I'd like to be able to do in this presentation is cover some due diligence requirements. And these are requirements that I have gathered through experience with the government, but also with working with companies and, quite frankly, as you'll hear later on, working in a company caught in a situation. A lot of times when I was with the Department of State and Compliance, I would get that panic-stricken call from a compliance officer saying, I just found out my company's purchasing another company, and I don't know anything about them, and what I've seen is they may not even be able to spell ITAR or EAR. What am I going to do? And there is panic that can occur in those situations. So I'm going to use those experiences to go into that and sort of define the role of buyer and seller and touch on post-due diligence requirements, what you should be doing once the sale is over, once everybody has gone to their individual places. Your work is really just beginning at that point in time. So those are sort of the purposes or the overview of what I'd like to cover during this presentation. Specifically, the areas of the necessity of comprehensive due diligence. The next one would be the role of the export compliance officer in due diligence process. And I cannot emphasize this one enough, and you'll hear me going back to it and back to it, because the export compliance officer should be at the front end of any sale or acquisition venture and should be included from day one. And as you'll see, could save you a lot of problems down the end. I'll touch on the notifications for a minute, but as I said, there's been plenty of training on this area. It's well laid out by the Department of State and by various organizations, but I couldn't really leave the areas without at least touching on the notifications. There is a common misconception oftentimes in the acquisition of a company, you know. Sometimes companies will treat any potential liabilities without even knowing the full extent of those liabilities as a cost of doing business. You have to be eyes wide open when this occurs. The attitude that says we can fix it later after we own them is not going to work and can only result in dire consequences for the new owners. Tom? Yeah. what I've done on the next two slides is just to sort of bring it home in the hardest case that I can, and that is cost of doing business and a few of the companies that have ended up in consent agreements with huge penalties, multiple violations, because the company that they acquired was not a compliant company, and the violations flow down to them as the acquirer. You can see most recently Esterline Technologies Corp out in the Seattle area, Megit. This next one, Key Optics All, I'm going to keep referring back to because that's part of the personal experience. I was called in to work for Key Optic after they had made an acquisition of 8 companies from Thales, and again, saying that they couldn't spell ITAR was an understatement. And my role was specifically to find a way out, because within a week of the acquisition, the champagne had just started to go flat. Everybody was happy. The new company, Key Optic, found out that not only were their activities under investigation by the Department of Justice, but also by the Department of Defense, DDTC, and BIS was looking at them also. And they had just spent $265 million to acquire these companies, and they were on the verge of, the U.S. government was ready to just nail the coffin shut, disbar them, sanction them, and the company would have gone under within a week, 2 weeks of the original acquisition. And that's when I was called in on this company. And I'll refer back to it because it's a classic case of, if you don't know what was going on in the predecessor companies, you're in trouble. L3 Communications, Lockheed Martin. Lockheed Martin was interesting. They knew the extent of the violations. They made a corporate decision, and they did liaise with the Department of State on it, that they would go ahead and buy the company, because in this particular case it had such a good fit into what they wanted to do. They were prepared to take any penalties and to straighten out the company that they had just acquired. So, you know, in this particular instance, they did their due diligence, they made a decision, eyes were wide open, and they decided to go through with it anyway. And then Adjoint Technologies, who again acquired a company and found out everything that was going on. This is an interesting case because all of a sudden a check showed up at DDTC with a note saying this is the penalty for what we consider would be a consent agreement against us in this acquisition. And at DDTC, nobody knew what was going on. So it was an interesting case. John? How this works for the government, successor liability. Both DDTC and BIS have adopted the standard of successor liability. In a law context, it's the assumption of the burdens of an acquired entity by the surviving company. It began back in 2002 when an administrative law judge ruled in a commerce case that the acquired company could be penalized. This was an incident where the company knew they were in trouble. They tried to quickly sell the company to avoid any penalties or other actions, and the government turned around and decided we're going to penalize a new company. The Department of State followed suit, and in 2003 established a consent agreement against Boeing and Hughes Space Communications for the same thing. And the violations were not Boeing's, who were the acquiring company. They were all used, some of them going back 4 or 5 years. But in this particular instance, the government felt, you know, you've acquired the company, you've acquired the violations that the company committed. And that was a long road for them, because that was the first case that I was appointed as the special compliance officer at the Boeing company to oversee the implementation of not only the terms and conditions of the consent agreement, but an overall compliance program that would ensure that future violations did not occur. There's a rationale used by the government in establishing and justifying being able to pass on the violations. And basically, and any of you who have been involved in acquisitions, know the aim is we're going to buy the company, we're going to fit it into our company, but we don't want to rock the boat too much in the very beginning, so we're going to let them keep their own name, we're going to let them keep their own offices, and then we'll integrate our people. Their product line we want to keep the same. DDC and BIS use all of this in determining you really haven't changed anything. You know, it is the old company just with a new owner, so their liability is going to fall on that new owner. Now, in the case that I was Global Director of Compliance, Kiopic, very much the case. The companies, some didn't even change their name for 6 months. You know, they were all run by the same people, and I can't tell you how many times I would get phone calls from compliance and DDTC saying, is so-and-so still a managing director? How can that person be there when they committed all of these violations in the past? Or, you know, what structure has changed? And multitude of questions, because they were establishing that the new company, Kiopic, you know, was going to be the liable party in that situation. It's very simple for the government. The liabilities for violations committed by a company that was purchased still need to be adjudicated. They just not go. They just go away. And in these instances, the only party to adjudicate these violations with is the acquiring company. In other words, the acquiring company purchases the good and the bad when they go into an acquisition mode. There are other potential consequences that occur, could occur, even if it doesn't reach the level of a consent agreement. Now, once the acquisition has taken place and some post-acquisition due diligence begins, if DDTC doesn't like what they see, if they see a multitude of recurring or systemic problems, they may order a directed audit and order the company to use an outside consultant. I've seen it on occasion where DDTC has made that directed audit, and it's on the new company, and they figure as long as the experts are in there, we'll have them take a look at the old company too. So your existing companies end up with an audit they never sought or asked for. They may ask that it's done by the company's existing compliance official. It's going to depend on how familiar they are with the company, their compliance program. If there has been a track record in the acquiring company of violations in the past, you can bet at that point in time they're going to tell you to go get an outside consultant and have them report to us on it. Another consequence are suspensions or delays in transfers of the acquired business's export authorizations until the audit is completed or voluntary self-disclosures are filed. If there is a history of violations concerning unauthorized transfers of technical data to foreign persons, and it's been going on for years, and it involves 6 TAAs, the government isn't going to allow those TAAs to continue. They're probably going to suspend them or stall the transfer until that situation can be cleaned up. You know, it only makes sense because those violations are just going to continue until there's a complete overhaul of the program. And in cases where they're serious enough, the government will take the easiest path and say no activities until you clean it up. You know, again, a dire consequence for people who have just spent millions of dollars to buy a company and find out they can't do anything with it. Voluntary self-disclosures with corrective actions, they're going to look for those to be filed and filed in the short term. the DDGC does not like, nor does BIS like, a year after an acquisition has occurred, a voluntary self-disclosure be filed on some matters that should have been picked up immediately after the acquisition. They expect due diligence before and due diligence immediately afterwards. What I've done in this section is sort of break it down as to the various roles of the export compliance person. In an acquisition situation, you want to protect your company. You want to ensure that the complete due diligence is done and management is fully aware of deficiencies and potential ramifications. This is a twofold purpose. Management can choose to go ahead with the acquisition, can write into the final contract an indemnification clause, which means that if any penalties do come down the road afterwards, they'll be the responsibility of the seller, not the acquiring company. But more importantly, it gives pause that if the violations are so overwhelming that maybe you just want to look somewhere else for a company to buy instead of the one that's just going to cause you a lot of heartache for many months and years afterwards. If there are deficiencies that can be fixed by the seller, they should be fixed. The compliance officer should exert every pressure imaginable to see that they're fixed. If there are voluntary disclosures that haven't been filed as yet, make sure they're filed. If in your due diligence you find problems, make sure that the company you're going to acquire fixes them beforehand, because otherwise you're just simply going to be inheriting those problems and all the issues that are going to go with it. Flashing back to the Chiaptic situation, Callis, S.A., who was the seller in this instance and was aware of criminal grand jury proceedings and all of the other investigations, the day before the sale was finalized, filed an initial voluntary disclosure with the Department of State and outlined a good portion of the charges that occurred at, violations rather that occurred at one of the companies that was being acquired. They strategized the fact that they would be able to get this in and maybe it would take the burden off of them. Didn't work so well. But in your particular circumstances, if you find something in your due diligence, try and get it fixed, get it documented, and make sure your senior management knows what is going on. Next, Tom.
Yeah, thanks, Jim. I think that last bullet right there is a really critical one, just from the aspect of documenting attempts to get something fixed, even if you're unable to get it fixed because of the mitigating circumstances that could eventually prove out. You know, if you've got documented attempts that we tried to have a problem solved, even though we were unsuccessful, even that is better than having nothing or
yeah,
so I think that's
you're absolutely right. You're absolutely right, Tom. With any situation, having every move documented, every decision documented, if it all goes south, at least you've got a record to be able to show the regulatory agencies there was an attempt to fix the situation. It wasn't just simply ignored or put to the side until the purchase was completed. It's strong mitigating factors.
Great.
Okay, as far as the acquiring company goes, and again, I can't emphasize this enough, the compliance officer should be a member of the acquisition team at the earliest opportunities. I don't know if any of you have had this happen or you've been involved in this situations, but usually it starts with a very small group of senior officers, general counsel, a few outside counsels, and it's kept very quiet what they're doing as they're targeting potential acquisitions and whatever. And they finally get to the point where they've made the assumption that this company is looking like it's going to be a viable purchase. They still haven't told compliance anything about it. They start to do their own various due diligences. Reviews of the records, reviews of sales, reviews of contracts, environmental checks, all of these other checks that they consider important, but for some reason, compliance gets left to the wayside or gets left in the hands, and I will apologize in advance to any attorneys who are on the phone, gets left in the hands of an outside counsel who at the end of this is just going to walk away. Having the acquiring company's export compliance officer involved from the very beginning cannot be emphasized enough. And one thing I would hope that at the end of this presentation you can all take home with you is, at some point in time in the near future, sit with your senior managers and say, listen, if this ever occurs, I just attended a webinar and I saw all the bad things that can happen. So would you please make sure that I'm involved from the very beginning? It's essential. Small case in point, Boeing had a consent agreement that was focused on one of their divisions. Consent agreement had been in effect for over 2 years, so it wasn't like anybody didn't know about it. Boeing decided to take that division and merge it with another division. Those of you who read consent agreements have read the paragraphs that any changes, acquisitions, sales, or purchases, that the new entities will be under the same terms and conditions as the older entity as far as a consent agreement. This was all announced one day at a all-hands meeting at Boeing that I happened to attend, and I was sitting with the compliance officer who had known nothing. And I just simply had to go back up to the vice president and say, congratulations. That division just inherited the defense agreement. And he looked at me and I said, yeah, I'm the SCO. This has got to be reported, and you're going to end up with now a consent agreement that had an influence and requirements upon one little facet of the company, now expanded to a whole division. So it is crucial. For the compliance officer themselves, again, these are situations that I have either been personally involved in or dealt with people and companies, and I wanted to put just some go-bys, some things that you should be aware of, mistakes that have occurred in the past that you have to think of if you end up in these situations. Now, if you're the compliance officer for the acquiring company, you definitely have to vet all outside counsel, bank officials, consultants that are to be retained to be sure that any information, specifically technical data or other information, received from the selling company can be viewed or reviewed by those parties. I had a situation with a company where there were environmental checks to be done. They hired a consultant. The consultant was located in China. The company itself, while not in China, was involved 90% in U.S. defense work. Now all of a sudden you got 6 Chinese nationals showing up at the front door saying, we're here to do an environmental review, which will include us looking at all the manufacturing facilities where things are stored and the products. If you're not aware about that, you can't stop it. That's why it's necessary that you sit down in the very beginning, that anyone bought into this has to be vetted. You have to be sure of their nationalities, their involvements. Be sure they're not with a company who has been sanctioned, debarred, or denied on another case. The data room, everything is electronic today. You've got to know, where is it located? If all of a sudden technical data controlled by the regulations is going to be transferred to an electronic data room that is located in Bulgaria, and you don't have Bulgaria on any of the authorizations, you've got a problem. By the same respect, who's the person? There's always somebody appointed to run the data room. Make sure the documents are in, categorize them, make them available in certain locations. What is that person's nationality? If data ends up coming that way, are they authorized to view it? Because that's what they're going to be doing, viewing it. And if you haven't made those checks, now it's the violation that's going to be yours, not the selling company. It's going to be yours. So, if the company to be acquired is in the business of manufacturing, exporting, or brokering, you're going to verify that they're already registered if they're a U.S. company, and that registration is still valid. You know, if they're not, and they're involved in regulated activities, you're inheriting a whole bunch of trouble. You know, by the same respect, and this happens quite often, if your company, up until this point, has not been involved in any defense-related activities that required you to register, but you now are acquiring a company that is involved, get your company registered. Get it done in advance. Don't wait for the notifications and all those other things. Get it in advance in preparation for when the sale is finalized and you want to get into license transfers and all the other things that are requirements under the regulations. Now, the last thing you want to do is end up again, the champagne is just about going flat, and now you're applying for a registration, and they're backlogged in compliance, and it takes you 3 months to get a registration, and you can't do anything with the rest of the processes. So again, if that's the situation, and it's not uncommon, get it taken care of ahead of time. The compliance officer should, in an appropriate time, and there usually is a schedule to these acquisitions and sales situations, ask for copies of all authorizations that were approved, applications that were RWA'd, and specifically or especially applications that were denied. You have to be able to have that overview, that look at what this company was doing to determine whether they were doing it right. The purpose of the denied and the RWA applications is you want to be able to determine were these clerical errors or ignorance, or were they continually trying to do business in North Korea, and it was something that you could expect was going to be problems down the road. So you need to look at that. If there's resistance from the selling company to providing copies of authorizations, try and determine what that resistance is. I've seen situations where companies have said, basically, yes, you can have all of our authorizations. We'll redact certain information, but you can have it. However, where we are a U.S. party or a foreign party to somebody else's TAA, we're not going to give it to you because it's third party. And we don't have their approval to do that, and quite frankly, nobody's going to want you to call them and see if you can get approval because you just advised them, hey, the company's up for sale, and they're going to start scurrying to find new suppliers, new parties to deal with. Sometimes the resistance can be overcome by getting redacted copies. A lot of companies don't wish to give up their registration number. I don't blame them. I endorse that. So, you know, redacted copies may work. A fallback position is request a spreadsheet of all the authorizations approved to the selling company. Create your own format for what information you feel you need. Don't leave it up to the selling company to determine what information they're going to give you. Otherwise, you'll probably just end up with a list of names and case numbers, and it really isn't going to do you any good whatsoever. You know, at a minimum, based on the experience I've had with companies and in my own situations, you know, the format would look something as follows. All the license, type, number, date approval, date expiration, end use, product description, just about all the information that currently appears on a license. Agreements, very much the same thing. In agreements, you want to be sure to ask for required reports, such as in an MLA, filed on time. Amendments, again, date of approval, original license number, reason for the amendment. Simply adding another party, or was there something else? Exemptions. Now, an exemption is an approval. You don't have to report it to the government, but you have to have the records available. So if you ask for exemptions, a list of exemptions used and how they were used, when they were used, etc., and the selling company tells you, well, we don't have that, or that'll take us a couple of weeks to put together. You know, that's what we used to call in law enforcement a clue. You're running into trouble because those records should be readily accessible, and if they don't have them, you know you've got a record-keeping issue at this potential purchase. Yeah. You know, copies of all voluntary or self-disclosures and directed disclosures filed with the DDC or BIS. You want to be able to see the history. What was going on? What led to the violations? Were they what we used to call in BTGC oops violations, where it's a simple mistake? The company had good processes, it had good training, it had good people. Somebody just made a mistake. Or were they a lot deeper than that? You know, the violation can also oftentimes tell you the extent of the compliance program that exists and where changes are going to have to be made, and you're going to have to be making them if the acquisition goes through. Yeah. Any voluntary or self-disclosures or directed disclosures that are still in review and have not been closed, be sure to get all the documentation available. It's critical, because if it's not closed by the time the acquisition occurs, you're going to be inheriting it, and you're going to be running around trying to figure out what was done in the past. My personal advice, you convince the selling company to close out any initial voluntary disclosures, any self-disclosures, or any ongoing directed disclosures, to close them out before the acquisition occurs. Get it off of the boards. You need to do this. You need to be able to see what sort of corrective actions have the companies promised or represented to the government they were going to make. There'll be chances are in some situations they haven't gotten to them yet. But you want to be able to carry them out and put them into place when you now own the company, so that when the government comes walking around and says, what did you ever do on that disclosure, you can say, we've gotten all the corrective actions that you accepted in place and implemented. Yeah. For the team, which will grow and grow and grow, but for the teams that are going to go out and visit or audit the companies to be purchased, you want to be part of the briefing with them. You want to be able to talk to them, tell them what the game plan is, tell them what the rules are. Oftentimes these people are going to be financial backgrounds and other backgrounds where they really don't understand, or they care to understand, export regulations. And you want to be sure that they're not going into this selling company and all of a sudden creating risk by getting exposure to data products that will end up your violations, not the other companies. So be sure you're involved in the briefings. If you can accompany them on audits or visits, do so. Most important, please try and establish a one-on-one interface with the compliance officer of the company to be acquired. You know, we're all from the same mold. We all talk the same language. Get a one-to-one relationship there. Work with them. Because if you end up having to deal through a bevy of outside counsel, so you get a simple question answered of a compliance officer, first off, the answer you get is may or may not be accurate, or it may be clouded because of the lack of experience in those people's minds as to what the regulations require. Go ahead and start preparing your notifications, for submittal. And we'll get into notifications a little later on as to when they'll be required. Tom?
Yeah, Jim, I think, just a comment, I think this list is valuable in and of itself. And I'm sure many people are going to be using this going forward. But I think it's a point that you made that's really well made, which is the ability of a company to respond to these types of requests goes a long way in showing how compliant they may be or how many problems they may or may not have.
Absolutely.
I just wanted to just take a moment. We are getting questions filtered in, and like I said, we'll try to address those at the end as much as we can. But as we go through this material, if you do have a question or something isn't clear, you'd like some clarification, please feel free to submit that through the Q&A toolbar, and we'll address it as we can. Thanks.
Hey, moving on to the role of the export compliance for the seller. I mean, there's a slightly different role. Basically, you want to help make your company as an attractive acquisition. You want to make sure that company officials, management, everybody else gets a good deal. So it's time for you to step forward and make sure that you have a clean compliance record with your policies, procedures, and processes clearly defined. If they're clearly defined and they're being used to make your company an attractive acquisition, because at least the new company knows there is something in place, and it's merely a matter of they will move down the line to change some of them to make consistency exist throughout the entire group of companies or divisions or whatever. But go over them. Make sure that they are clearly defined, because at some point in time you're going to be asked to turn them over. So from the earliest days, make sure they all are in good shape. Confirm that any outstanding issues are taken care of or can be taken care of, such as undisclosed violations, non-implemented corrective actions, procedures that are drafted and approved but have not yet been implemented. Get them implemented. As I said, you will be asked at some point in time to turn over your compliance manual, your processes and procedures. You're going to want to have them look good. You're going to want to have them appear very effective and in good order, because the person on the other end, your counterpart, is going to be looking at them trying to judge what exactly am I getting involved in here? Am I going to have a lot of problems? If a company says we don't have any compliance procedures in place, we sort of have a technology control plan that covers everything globally, all around, you're going to hit problems. So get them all in shape, get them out. You've got to protect your company during the sales process to prevent any violations from occurring during that process. And it does happen. There is no real reason that any technical data should be shared. There is no reason that the acquiring company should have any right to the technical data that you have. But, as sometimes happens in a turnover of documents, or another team from the acquiring company who's reviewing contracts finds copies of the technical data there. And if they're not authorized to receive it, they're not U.S. persons or a foreign person designated by that agreement, you've got a violation committed by your people. So be sure that everybody understands what the game rules are. And make sure that when you set up the process, just as the selling company or the buying company did, making sure your team knows the game rules is extremely important. You're protecting yourself. Tom? For the company's perspective, again, I'm going back to where I was with the buyer. Compliance should be involved from day one. It's an absolute necessity. your company could be talking to another company who's looking to acquire them that is on a denial list, and they wouldn't know it unless they came to you to find out. Yep. You need to be able to look closely at everything that's going to occur almost from day one. You know, for companies that have multiple business sites, divisions to this subsidiary, appoint one point of contact in each of those sites that you can deal with. More importantly, you can share the work with. You know, you want to make sure that you have control on what's going in, out, and what's being presented and what's not being presented. You can't do it all on your own. You're still trying to run a company, which may or may not be purchased. So you've still got a full plate of work to do just in your regular day-to-day compliance efforts, and you need to be able to have assistance on it. A lot of companies will, since many times these end up, a lot of consultancies will hire an outside firm to do the due diligence on behalf of the company. If that is the particular case, be sure you know who is the outside consultant or the outside firm that is going to be doing that work. Make sure they're vetted. You know, not all compliance firms are created equal. You know, part of it is going to be you're going to have to establish right away, are there any foreign parties involved? You know, because, again, you've got to protect yourself. Review all your export authorizations. If there were any that can be closed out, you've got, let's say, a DSP-5 license for 100 units to go somewhere. You've already exported 80, and the contract is now canceled. You just haven't gotten around to closing the license. Close it. Get it off the books. Any of these that you can get rid of is going to save you a lot of headache down the road, a lot of extra work down the road. So clean up your licenses. Make sure that all required records of exports are properly stored and maintained. So when you're asked about record keeping, you may not have to show it, but you can show the process that is being used. Like earlier when I mentioned exemptions, you know, be sure that you're able to get to the exemptions. Be sure they're all there. You don't want to start a 4-month job to figure out on what day of the week did we use what exemption and for what. You know, you have a record-keeping requirement in the regulations, and if you haven't been doing it, you've got to get it up to speed right away, because now there's going to be a new owner, and there's going to be a new owner looking very closely at you. Done? Again, much like the other situations, review all the voluntary disclosures and direct disclosures. See what they say. Yep. You're going to have to turn them over at some point in time, or minimally, you're going to have to turn over a spreadsheet. Yep. See what they say. Make sure that if there were corrective actions that you promised to do that in a voluntary disclosure to DDTC, that you've taken care of those, that they are done. If there was training that was committed to, get that out of the way. You know, because when the new company takes over, you know, they're going to want to know that they're ending up with a clean record for disclosures that were filed, disclosures that were closed, and disclosures that are pending. Again, as I said earlier, as soon as you are able, as soon as it comes down to the purchase is pretty near going to be a done deal, and the company's identified both companies, and they start that sort of negotiation process and review process, get close to the export compliance counterpart in the acquiring firm. Set up communications. You know, make the process go as easy as possible. Again, you're trying to make your company look good, and nothing better than the export compliance officer on the acquiring team to turn around and say, hey, this company's in good shape. I find nothing here. They've been completely open, and I see no reason why we should either walk away or delay any action on this acquisition. You know. And then brief your people. You know, you don't want to end up with violations. Again, the reverse of what the acquiring company is. The financial people come into the company, your company, and say they want to look over some contracts or whatever, and then they ask about what sort of data is, and in an attempt to be very helpful, somebody turns over the data. You don't want it happening. So be sure that everybody that is going to be involved is properly briefed. You know, if there are to be audits and you can go on the audits, I encourage you to do so. Nothing better than walking into a company to get a real sense of what is their true compliance program as opposed to what is their written compliance program. Notifications, you can begin preparing them. You know, it's especially critical, as we'll talk about later on. If the sale or transfer is going to be to a foreign person, a foreign company, it's minimum 60 days notification in advance, and you've got to be able to get that in place. So as early as possible, begin working on it. If you've done your job and you've vetted everybody in the new company properly, you'll know what sort of notification has to be made. A danger area, not a danger, but a concern area, private equity buyouts. The purchase is going to be a private equity firm. Find out what is that private equity firm, what sort of nationalities, who do they intend on putting in place, who's going to become the new CEO and whatever, because you don't want to end up the day before the sale or the day after the sale where the new CEO is going to be French and all of a sudden there's big problems for the acquiring company and setting up appropriate safeguards to prevent access to violation until authorizations can be received. Again, just a little bit on the notifications. You know, 122.4 of the ITAR addresses the notifications that need to be filed. Most, if it does not involve a foreign entity, is a 5-day notification from the event. The final sale, when everything is consummated, the champagne's popped, within 5 days, notification has to be made by both acquirer and by seller. You know, if you don't have all of this prepared well in advance, you will find the day after an acquisition, people going into the wind. You can't get a hold of people anymore. You can't get the amendment signed for the registration to include the new information. Front load everything you can, so when it comes to that day, everything can be taken care of very quickly. Be sure that your teams understand foreign entity involved. It's 60 days before, because you will get pushback sometimes. Yeah. People sometimes want to close these deals very quickly. And once there's agreement to selling price and everything else, they want to be able to close right away. Well, if that 60 days has not been built into that, you're going to have a problem. And everybody's going to have to be told to wait. So as much information as you can get in advance and prepare everybody for, the better off that you will be at the end of the day. This is just a chart that exists in a lot of different forums. I just put it in here as a quick reference chart. I've used it dealing with companies in these situations. It sort of lays it out, real layman's language, as to what you have to do when it has to be done. You know, it's a good guide to go by. Tom?
Jim, just a quick question on the notifications. I think the key there is the word intention, right? So, you know, a company would notify DDTC, and then let's assume that the sale doesn't go through for some reason. That's okay. It doesn't have to be a final final contract signed, the sale is definitely going to happen. It's the intent to sell or buy, right?
That will happen more in the cases of foreign parties involved, because there is such a big lag time for the notification, 60 days, and a lot can go wrong in that 60-day period. There is no problem. If the deal goes south and you've already filed the notification, it's just a simple letter to DGDC saying this sale was not made. Purchase wasn't followed through. You know, for the 5-day notifications, U.S. party, the U.S. party, you know, pretty much you're going to know today ABC company is now owned by DEF company, and you have the 5 days to submit it. You know.
Right.
Now, DDTC, not so much BIS because they operate slightly differently, but DDTC does offer a certain service, and I think it's a good one to follow. If you're 99% sure that this sale is going to go through, this acquisition is going to occur, you can send in a pre-notification, sort of outlining what is going to occur, emphasizing it hasn't occurred yet, and you will still follow the required 1J 2.4 notification, but giving DDTC the background information. It is an enormous help that people don't take advantage of, because what's happening in that process is when you file that pre-notification, it's being assigned to a compliance officer. They will review it. They may have questions for you. The most important thing is they're aware of who you are. So they can start gearing up on their end for when the notifications are made, the 5-day period, required period, to getting everything in place that the registrations are amended, registrations may go away, that the transfer of licenses can be approved once DDC approves the acquisition. And keep in mind, DDC may not turn around and say, we don't approve this acquisition. But most certainly they can turn around and say, but you can acquire, we don't care, but we're suspending all the licenses or revoking them because something's wrong with the acquiring company. But do avail yourself of that pre-notification. You know, the people there, yeah, everybody's overworked and whatever, but anytime you can make a government employee a little bit happier and their life a little bit easier by letting them know what's going on in advance is only going to be an advantage to you. And things will get done quicker. Questions will be answered. So I do recommend that you do that.
It's a really good point. I'm sure you're right that most people are not taking advantage of that. So thank you.
As far as this is, again, just an overview, EAR, you know, there's no registration, so that's taking care of a big part of it, what you find in the ITAR. But there are some certain steps that have to be followed. There has to be a letter. If there are licenses that are to be approved that were approved to sell it, they're now going to transfer. The seller has to give a BIS a license, a reason for transfer, outstanding, a list of outstanding licenses, outstanding pending applications, name and address of the person who is the buyer, the person who is to receive the license, relevant facts necessitating the contract, the transfer. It's an ongoing contract. You need the licenses to stay in place. You know, copy of the legal document reflecting that the buyer has been granted authority to operate, you know, certificate of incorporation by a state, and a letter from the buyer that must be attached to the seller's notification to EAR saying that the transfer of licenses and approvals can go through and that its eligibility is in place to receive the new licenses. One quick fact, and it can be problematic, whereas there can be an en masse transfer of licenses by BIS. That does not occur in the instances of re-exports, where your company has obtained a re-export approval for something previously licensed. You're going to have to get a new re-export approval. I'm not sure I understand why. And I've asked the question of some folks there and some folks that I've dealt with, and there doesn't really seem to be a clear-cut reason. But regardless, that's their position. So if you got about a bunch of products, especially stuff that's on the loading dock, that is ready to go via an existing re-export license, you're going to have to hold it while you get a new one. And get it in place as quick as you can. To touch on for a minute, post-acquisition due diligence, the buyer, and this is totally the buyer. Once a transfer and amendments of the export license has been finalized, because that is the biggest concern. You want the business to be able to continue on, your new business to be able to continue on their business. So, but as soon as possible afterwards, conduct an audit. Whether you do it yourself, whether you use an outside consultant, I don't care. Do the audit. You've gained a lot of information and insight into the company during the due diligence process for the sale. But now you're going to see it all firsthand. You know, completely review all the documentation for the export authorizations that have been transferred. You know, 73s, where was the product temporarily exported? Can it be accounted for? You know, how many disclosures have been made because all of a sudden 3 of the night vision scopes that were out for demonstration purposes in some country can't be accounted for anymore, and there's no record of them being lost or destroyed. You know, get that part wiped up as quick as you can, because you're going to have to file a disclosure somewhere along the line if it's not in. MLA reports, have they all been filed or any due? Current values of agreements. You know, has an agreement was started 6 years ago and didn't require congressional notification, now all of a sudden moved up, and because it's been amended value, that you're at the threshold, or in some instances have passed by the level where you now have to make congressional notifications. You want to mess up a program really bad, fall into this trap, because everything halts, and anybody who's involved in congressional notifications knows that they do not come down overnight. It takes a long time. Congress works at its own pace, its own schedule. So check that out immediately, as I say, in this initial audit. You know, another problem that occurs, where you have foreign parties on the agreements you now own, check their sub-licensees. Now, I worked, as Tom said, for 8 years, and worked basically as a foreign multinational company. We had one presence, well, originally 2, but then one presence in the U.S. Yeah. Sub-licensing, we were foreign parties on every agreement. Sub-licensing became a crucial area. It's an area people don't pay enough attention to. If they transfer work to another company, if it isn't approved, you got a violation. If all of a sudden they hire a national that wasn't originally approved, you've got a violation. Go through all this. Catch anything you can early where disclosures need to be made, make them. Verify that all commissions and fees have been declared in the license. Ascertain the nationalities of employees from the acquired company to ensure that safeguards are in place. All of a sudden, your company is going to be moving some employees into the new company. You know? While you don't have an HR role in that, be sure that you're able to take a look to say, okay, you know, the new company is involved in defense, and we're going to put a Spanish national into that company. Got to get approvals in place, or limit the activities, or limit the involvement until we get approvals in place. Evaluate the existing export compliance policies, procedures, and process. make sure that they're sufficiently robust at this time to allow a transition. Eventually, what you are going to want to do is the newly acquired company convert their process and their procedures to your own. You want to have consistency throughout all of your business sites, divisions, and companies. They should all be operating under one sort of process and procedures. So if there's a good system in place, nothing on the face of it has to be changed. Leave it and make your transition. But if you look and they don't have a visitor policy, they don't have this, they don't have a travel policy, you're going to have to rush to get some of those things in place. Because remember, from this point on, you're now the party that's going to be filing the voluntary disclosures. So that initial audit is just crucial to making a smooth transition and getting everything going. Next. Provide training. Even if they have a good training record, when you go out and do the audits, provide training. It does two things. It gives the company a refresher, but more importantly, it gives them a sense to how you and your company are going to operate. So there are no surprises down the road. It can be very informative at times when you start getting these questions that are basic Export 101 and should have been covered in training, and apparently it either wasn't or it wasn't heard or understood. But, you know, get a training session in. They get to know you, you get to know them, and more importantly, no surprises. If export violations are uncovered during the audit, following actions need to be taken. Stop the activities until you can report the violations. You don't want to have activities continuing to rack up on a number of charges that can be filed. Any who have ever been involved in the consent agreement, and I was involved in 11 of them. I helped draft the first consent agreement, but it's an interesting way that the Department of State calculates charges. And technically, every action can result in 10 different violations or 10 counts. So, you know, stop the activities, conduct your internal investigation, file the initial notification immediately, and implement corrective actions. If a new export license authorization is required, get it in. File the final disclosure. Again, the fact that you just acquired a company is a good mitigating factor, but it's made all the better if you say that you conducted your due diligence before, and while this thing didn't rise to the surface, immediately after the acquisition you went in and did an audit and came up with these violations. It helps in the adjudication of the final case. Yeah, I have lost count of how many voluntary disclosures I adjudicated for the Department of State. But I can tell you, those that showed that the company involved took action immediately, reported it immediately, did a thorough investigation, and put in strong corrective actions. Yeah, they're the ones who ended up with that letter at the end of the day and say, fine, remain diligent, go and sin no more. And that's where you want to be. And by post-acquisition, immediate audit, whether you do it or an outside consulting firm does it on your behalf, is critical. First, you can start building from there once that's completed. You know more about the company and you know where you stand. You know, for past violations that were never disclosed, complete the internal investigation, file the initial notification. Important. Determine whether these were a one-off. Was this just the oops I mentioned earlier, or was it a one-time occasion? You know, or is it a sign of a systemic problem? Because if it's a sign of a systemic problem, those violations are continuing to occur, and you want to be able to get on top of that immediately. Now, it gives you a perfect opportunity that in the evaluation of existing procedures that relate to types of violations, and if non-existent or weak procedures there, you can speed along your implementation process to get them in line with the procedures that you put together for your company and your company follows. And again, that consistency is so important, especially if there's going to be interaction between existing companies and newly acquired companies. You want to have everybody on the same page. There's just no other way to do it. Tom? You know, I feel like I'm saying the same things over again, and I know they're common sense, but they need to be said anyway, you know. Establish a schedule for the transition. Make sure everybody's aware of what that transition is going to be and how long you intend that it will take. Helps you get organized, helps them get organized. It's all above board. They understand it. Very important. Evaluate the existing level of compliance resources in the firm you've just acquired. If you've got a company that you've acquired that is doing $50 million a year in defense work, and they've got one compliance officer who is also the fire marshal, who is also the parking attendant, and holds 3 or 4 other positions, duties as described, you know you're going to have to do something. You're going to have to talk to your people, talk to HR. You're going to need a higher representation. The probability within your own company is that you've already established a level of compliance resource necessary to keep your company compliant. Well, look at the new company, and they should be on an equal par, depending on their level of work, the level of regulated work, and the level of employees, but they should be on an equal par. God forbid you end up in the consent agreement. You know, those of you who read through them, you'll see one of the first requirements of a special compliance official is to report every 6 months on the resource levels of the compliance staff at that company. You know, the DDC views it very seriously. You can't do a job without the people in place to do it. You know, as soon as possible, look at the possibilities of changing export compliance contracts. What companies do denied party, what export consultants use, what outside counsel is used. Again, I'm going back to the point of consistency. If all of your companies have one company, let's say OCR, who is doing your denied party screening, and the company you just acquired is using somebody else, transition them over. Get them on the contract. Yeah. If they have their own consultants, maybe you know them, maybe you don't. But if you use a consultant on a regular basis, you know, get it so they're using the same consultant. It's like transfer of a DSP-5 licenses with freight forwarders. You know, you want to end up with one list of freight forwarders that is consistent throughout all of the company DSP-5s. We're practical. Sometimes it's not practical, but basically that's what you want to do. Same thing exists. You know, the consistency that flows down to all the sites, including the acquired one, all of the companies, all of the divisions, will at the end of the day make your life as a compliance officer much easier and will go a long way to ensuring that you're not going to end up with problems, misunderstandings, misinterpretations, you know, the age-old excuse, well, you know, that's not the way we did it before. Well, you know, hey, you know, that was before, now is now. This is the way you're going to do it. It works for us. We want it done that way. And you're just going to have to make that transition. Always a little pushback, but it can be overcome with the right approach. And it will, at the end of the day, ensure that your company is comfortable in its compliance. Okay?
Great.
Moving on to questions, and thank you very much.
Thank you. So we do have some questions here. We have a few more minutes before our stop time. So I'll just go ahead and start asking these, and then folks, if you do have any additional questions, feel free to submit those, and we'll try to get to them if we can. Jim, first question for you. How far back, when we're talking about due diligence now, how far back should we go? I assume this is a situation where a company is buying another one and looking at the potential company for a purchase. How far back should we look in due diligence? 5 years? More than 5?
5 years represents a statute of limitations in other legal matters. DDDC and BIS will accept the 5-year review going back, but they may actually turn around and ask you to go further. It depends on what's uncovered during those 5 years. But I, as a practical matter, would look at the past 5 years of the company.
Great. Thank you. Next question. To what extent does attorney-client privilege extend during the sale and purchase process?
You know, there's going to be, this issue is going to be raised a lot in these processes, and one reason, as you will find, there are so many law firms involved. Much like in criminal law, there is attorney-client privileges to the extent that if the lawyer is now withholding facts, willfully and knowingly withholding facts that would be a violation, if DDDC or BIS finds out about it, you know, they're going to go after you. There was a consent agreement a few years back where there was a strong push to literally charge a law firm who during the acquisition period became aware of some facts that should have been reported and chose not to report, or gave advice to the company not to report it. At the end of the day, they were not themselves charged, but the company itself was. So attorney-client privileges is no big shield to hide behind. It does offer a certain level of comfort, but it's not going to protect the company if things have gone wrong.
Great, thank you. Next question is around successor liability. It says you talk about successor liability, which places the responsibility for past violations on the purchaser. Is this always the case, or are there occasions where the seller would be held liable?
Both exist. There have been successor liability issues raised, and the government has turned around and charged the pre-existing company that sold and the buying company. It really just depends on the types of violations, the sensitivities involved. The government will always attempt to use whatever it can to sort out both companies. And if I might use an example, if you have a company that's selling off some of its divisions, and that company has systemic problems in how they've handled authorizations over the years, and this comes out when a due diligence is done on the acquired company. Department of State may choose in that situation to go back on both companies because they're going to want to see that the original seller has cleaned up its act at the same time. Now, other times they'll just go after the acquirer. So it can go both ways. It depends on the types of violations, the sensitivity of technologies, how they occurred, and where they reported at the appropriate times.
Mm-hmm. So another question about liability. There's a lot of questions about liability, Jim, as you can imagine. What if the acquisition is just an asset purchase? Does the liability still fall on the new company?
You know, if it's just an asset purchase, There's still certain notifications that have to be made if it's under the HR. And it's a debate that will go on for a long period of time, whether the new company, if they're only purchasing the assets, is going to be responsible for violations that occurred beforehand. Truthfully, I've seen Department of State go both ways on this issue. If you end up in this issue and violations are uncovered, whatever, you want to make your notifications immediately and make it as clear as you possibly can that it is only the assets that were acquired. And DDTC might choose to use that in mitigation in reaching its final decision. But like so many things in the government, even what might be in the printed word and what is actually in practice, it's gone both ways.
Okay, thank you. Another question, if we are a foreign company buying a U.S. company, should we register with DDTC now, or we wait until the sale is complete?
As a foreign company, you can't register with DDTC. Your registration requirement will kick into place once the acquisition occurs. So you're going to have to wait on that issue until the acquisition has been finalized. Now you have a U.S. presence, and you have to go ahead and register that company, division, business sector, whatever it is. Beforehand, no, you have to wait until it's completed.
I think that was the one where there might be confusing the notification process with registration there. So, okay, that's all the questions we have. Unless anybody else has any additional ones and would like to type those in the next minute or so. Just want to thank everybody for joining us today, and just as a reminder, we did cover this at the beginning, but if you go to our website within about a week from now, exportsolutionsinc.com, there will be a copy of these slides available for you to download, as well as a recording of this presentation. I know that we have a few people who've said that they were having some audio issues and couldn't hear everything or couldn't see the slides, so that's why we do record these. And again, give it about a week for us to handle things on the back end. But you will be able to view this session on our website. So with that, we don't have any additional questions. I just want to thank everybody for joining us. I hope this was an informative session. If you do think of something afterwards and would like to talk to us, please feel free to contact us. You can do that through our website as well, and we'd be happy to try to talk to you. And then finally, I did want to thank Jim. Great information and great presentation today, Jim. Thank you for putting this together and for sharing your stories and your expertise with the folks here. I think it was very helpful and informative.
Thank everybody for participating, and I hope that you walk away with something that will be of helpful if you're ever confronted with this situation.
Great. Thank you, everyone. Have a good afternoon, and we'll hope to talk to you again soon. Take care.